Good morning to one and all who are present here. The Consumer Protection Act, which is today's topic for the webinar, I'm going to give a short brief about it also. The Consumer Protection Act is a law in favor of customers wherein their interests are taken into consideration and given the preference. This law was recently amended in 2019 to replace the existing one, which was passed back in 1986. As per the meaning of consumer rights, the main objective behind enacting this law is to facilitate consumers with remedies of quick redressal of their grievances. With this respect, today's seminar will be conducted by Dr. Nityanand Singh, a distinguished member of the Honorable Supreme Court of India and a fellow member of the Institute of Company Secretaries of India. He also holds a doctorate in law. In his professional capacity, Mr. Singh is an advocate practicing at the Honorable Supreme Court of India with over 20 years of extensive experience in litigation. He is also a partner and founder of the renowned law firm named Nux and Partners. Nux and Partners specializes in corporate and operates with a leading concept, handling litigation matters across more than 500 districts in India. Additionally, Mr. Singh actively contributes to society through his NGO named Vidya Vijay Foundation. This foundation is dedicated to uplifting the education, social well-being, and living standards of the underprivileged. Its name, Vidya and Vijay, is derived from Mr. Singh's parents, with the first word honoring his mother, Mrs. Vidyadhari Devi, and the second word commemorating his father, Dr. Vijay Narayan Singh. Moreover, Dr. Singh serves as a visiting faculty member at esteemed institutions such as the Indian Institute of Management, the Institute of Company Secretaries of India, the Institute of Chartered Accountants of India, as well as various other law colleges throughout the India. Beyond his professional engagements, Mr. Singh is actively involved in social and political affairs also. He has twice contested the elections for the Legislative Assembly in Delhi, demonstrating his commitment to public service. Now, I would like to invite Sir to continue with today's webinar.
Thank you, Ms. Kumal. First of all, good morning to all of you, my learned friends who have joined here. Today is the session, redressal of the grievances of the consumers by the Consumer Commissions under the Consumer Protection Act 2019. Earlier act was the Consumer Protection Act 1986. Rather than making the amendment in the act, the Parliament had thought that the entire act should be changed. Therefore, the entire act has been changed and new act came into the effect from 20th July 2020. So all the acts are enforceable, all the provisions, all the sections are enforceable from 20th July 2020. So now we will discuss how it come into the force and what are the changes take place and how it is effective. And especially the Consumer Protection Act is to be known by each and every one. Every citizen of the India should be aware from this act, because every citizen of the India is a consumer, because all are the purchasing their goods, are availing the services. So all of the Indian citizens or the citizens anywhere in India should know these provisions. So we will discuss about it. The redressal of the consumer grievances by the Consumer Commission under Consumer Protection Act 2019. So first of all, we will discuss about the Consumer Protection Act 2019 and overview. What was the intention of the Parliament to specially design this act, and the entire act has been changed. The Consumer Protection Act Bill 2019 was passed by the Parliament on 6th August 2019 to replace the Consumer Protection Act 1986. President gave assent to the Consumer Protection Act 2019 on 9th August 2019. The central government by notification number so and so in the Official Gazette of India notified 20th July 2020. This date is very important because the Consumer Protection Act 2019 came into force on 20th July 2020. If any consumer complaint has been filed before the Consumer Commissions or earlier Consumer Forum on or before 20th July 2020, that complaint will be dealt with Consumer Protection Act as per the Consumer Protection Act 1986. But once the complaint has been filed after 20th July 2020, then that complaint will be dealt by the Consumer Protection Act 2019. So this is the very important date we should be aware about, because I have a practically exposure that plenty of the complaints has been filed before that date, and still those complaints are entertained by the Consumer Forum or Consumer Commission nowadays by the old act. But once the complaint has been filed after that date, that will be dealt with as per the Consumer Protection Act 2019. So once we are being a professional, you are dealing with the cases. Once the case came into your hand, you should be very aware whether it is for applicable section is Consumer Protection Act 2019 or Consumer Protection Act 1986. This date is very important. In this, the various provisions of the Act fell into the force. The government, instead of amending the Consumer Protection Act 1986, enacted to provide for the better protection of the interests of the consumers, and also taking into consideration the booming in e-commerce industry. Specifically, this act is designed for the booming of the e-commerce industries. E-commerce industries means e-platforms are available to purchase goods. What happened earlier in Consumer Protection Act 1986, if any products are being purchased from the e-commerce platforms, then those company was not responsible, and that cannot be implemented as a party, because we professionals always take the defense that the person who is providing the e-platform is not responsible in any way, but only the person who is selling the goods that are responsible. But only because of that, the Consumer Protection Act 2019 came into force, and specific e-commerce industry came into this provisions of the law. And modern methods of the providing goods and services such as online sales, tele-shopping, direct selling, multi-level marketing, in addition to the traditional methods. These are covered under the amended new Act, Consumer Protection Act 2019. The Act applies to the whole of India. The new Act provides more protection to the consumers as compared to the Consumer Protection Act 1986. It works on the principle of the consumer sovereignty, which states that the consumer should be the king. And always, the consumer is always the king. The Act aims to protect those rendered vulnerable in the wake of the rapidly developing digital technology. The new Act also introduces the concept of the product liability and brings within its scope the product manufacturer, product service provider, and product seller. These product liability, product seller, product service providers, and product manufacturer was not covered under the Consumer Protection Act 1986, but it is covered under Consumer Protection Act 2019 for any claim for compensation. The most significant impact of the new Act will be in e-commerce platforms, as it also includes online service providers under its ambit along with the goods. So all the companies we are providing for the e-commerce platforms that are also covered under the ambit of this Consumer Protection Act 2019. And we will discuss about the certain definitions, which is more important to understand how you can file a complaint, who can file a complaint, who are the consumers, who are the complainant, what is the products, what is the goods, what is the services. These are the very relevant definitions. Therefore, I want to discuss these things, because once I will not discuss this definitions, so it is not easily understand how to deal with the consumer cases. So who is the consumer? A person who buys goods or avails services or consideration. The word consideration is very important, because once you are purchasing the goods and we are paying for that, then you are the consumer. Once you are availing the services free of cost or purchasing any goods without paying anything, then you are not the consumer. So always keep in the mind who are the consumer. Unless and until you are the consumer, you cannot approach to the Consumer Commission. very clear. It should be very clear in the mind. So before filing any complaint, once you are the professionals, before filing any complaint, you have to look into whether the person approaches you who is the consumer or not. Once he is not a consumer, he cannot approach to the consumer commissions. Consideration may be fully paid, partly paid, or fully promised to be paid, or partly promised to be paid. There should be the considerations. It may be fully paid, may be partly paid, or fully promised to be paid, or partially promised to be paid. Anybody who uses the goods or services with the consent of the consumer, that person is also a consumer who uses that goods with the consent from the person who has purchased it. It doesn't include this. Who is the consumer means the person who purchases the goods against the consideration is the consumer. Who is not a consumer? It doesn't include a person who brought goods or availed services for resale. If any person purchase the goods for the resale, then he is not a consumer. Suppose you are doing a real estate business and you are purchasing the real estate products for selling it, then you are not a consumer. But you are purchasing the buildings only because of that for your particular use or for the use of your family members, then you are the consumer. So always keep in mind, the person who is purchasing the goods or availing the services for resale is not a consumer or for the commercial purpose. If anything is being purchased or availing the services for the commercial purpose, then you are not also a consumer. But if a person uses goods exclusively for the purpose of earning his livelihood by means of the self-employment, then he will remain a consumer. Likewise, once you are, even though your purpose is the commercial, but only for the livelihood you are doing so, then you are also a consumer. I am giving an example. Suppose you are running a taxi, and if you using the taxi as a commercial purpose, but only using one or two taxi, and on that taxi has been used only for your livelihood, means you are running a taxi for your surviving, for your living, for your livelihood, then you are the consumer, even though it is using as a commercial purpose, but you are still a consumer. But once you are purchasing the number of the vehicles, suppose the 10 vehicles, and all those 10 vehicles flying in the road, and you are enjoying the commercial use, then you are not a consumer. So there is a very thin line. You have to define whether you are the consumer or not a consumer. Even you are using for commercial purpose, but for your livelihood, then you are a consumer. But once you are using it 100% commercially, then you are not a consumer. So always think in mind how you are the consumer or not a consumer. A consumer, if purchase goods or avail the services through any mode, including offline, online, through electronic mode, tele-shopping, multi-level marketing, or direct selling. Legal heir of the consumer in case of the death of the consumers, if any death has taken place, and then the legal heirs of that person is also a consumer. Who is the complainant? Who can file a complaint? Please mute, my dear friends. Who is the complainant? Complainant means a consumer, a voluntary consumer association registered under any law for the time being in force. A voluntary consumer association, any consumer association which is registered under any provisions of the law and that is working for the consumer protection, then they can also file a complaint. But what registered is the very important. Once any voluntary consumer association, once it is not registered, then you are cannot file a complaint on behalf of that consumer. You have to be registered. The word registered is very important. Any voluntary consumer association registered under the any law for the time being in force, the central government or the state government, the central authority, one or more consumers where there are numerous consumers having the same interest. There are the one or more consumers can file a complaint where there are the numerous consumers having the same interest. In case of the death of the consumer, his legal heir or legal representative. In case of the consumer being a minor, his parents are legal. Once the consumer is minor, means he is below the age of 18 years, then his parents can file a complaint on his behalf, on his or her behalf. This is the case law Amrapali Sapphire Pledge Buyers Welfare Associations versus Amrapali Sapphire Developers Private Limited, decided on 30th August 2016 NCDRC, in which it is clearly stated that any recognized consumer association, whether the consumer to whom such goods are sold or delivered or agreed to be sold or delivered, or such services is provided or agreed to be provided, or who alleges unfair tax practice in respect of the such goods or services, is a member of the such association or not, can file a complaint before the commission. Any recognized consumer association means it has to be registered and recognized, then only they can file a complaint on behalf of the consumers. These definitions are the very important definitions because it doesn't cover under Consumer Protection Act 1986, because e-commerce platforms were not available at that particular time when the Consumer Protection Act came into the force in 1986. And due to change in the society, change in the commercial businesses, e-commerce platforms were available. Therefore, the new Act, Consumer Protection Act 2019 came into the force and covered all those things. E-commerce, it means buying or selling of goods or services, including digital products over digital or the electronic networks. E-commerce, all those e-commerce platforms are available, and who is the person who is selling the goods on the e-commerce that are also covered under the Consumer Protection Act, and case can be filed against him. Not only against the whom those are selling the goods, but person who is also providing the e-commerce platform, that's are also liable. Electronic service provider, it means a person who provides technology or processes to enable a product seller to engage in the advertising or selling the goods or services to a consumer, and includes any online marketplace or online auction sites. Suppose earlier what happened in Consumer Protection Act 1986, suppose as the Flipkart, Amazon, these all are the products are available on the Flipkart and Amazon's, and normally Flipkart and Amazon used to take defense in the Consumer Protection Act 1986. That's I am not liable as per the Consumer Protection Act 1986, but they cannot say so once the Consumer Protection Act 2019 came into the force, and all those commercial platforms are available. They are covered under this Consumer Protection Act 2019. Goods means every kind of the movable property and includes food as defined in section 31J of the Food Safety Standard Act 2006. The goods means person who are purchasing the goods, as that goods has been defined as per the Food Safety and Standards Act 2006. What do we mean by service? It means service of any descriptions which is made available to the potential users and includes but not limited to the provision of the facilities in connection with the banking, financing, insurance, transport, processing, supply of the electricity, other energy, telecom, boarding, lodging, both housing, construction, entertainment, amusement, or the purveying of the news or other information, but doesn't include the rendering of any service free of charge or under a contract of the personal service. These services are includes, but doesn't include the once you are availing the services of anyone that is free of cost, you are not paying any consideration, then you are not a consumer. And another exception is the contract of the personal service. Suppose once you are hiring any employee and there is an employer-employer relationship, then it is also a contract of the personal service. That they are not the consumers. Unfair contract, this has been newly introduced in 2019, that it means a contract between the manufacturer or the service providers on one hand and the consumer on the other hand, which was significant change in the rights of the subscriber, including following, namely requiring manifestly exclusive security deposits to be given by the consumer for the performance of contractual obligations. Whatever the unfair contracts means, which are the contracts which are entered into the manufacturing or service providers and the consumers. And if anything unfair, in the simple word you can understand that if anything is unfair, then the consumer can approach to the consumer commissions. But in the case of the unfair contracts, only the state commission and national commission has a jurisdiction to entertain the complaints under unfair contract. District commissions doesn't have any jurisdictions to entertain a complaint of the unfair contract. So it is also very important to understand what is the unfair contract and who has the jurisdiction to entertain such a complaints under unfair contract. What is the product liability? Product means any article or good subscribes any raw material and extended cycle of the such products, which may be in the gaseous, liquid, solid state, possessing intrinsic value of which is capable of delivery either as a wholly assembled or component part and is produced for introductions or trade or commerce, but doesn't include human tissues, blood products, and organs. What is covered under the products and what is the product liability? It means responsibility of the product manufacturer or product seller of any product or services to compensate for any harm caused to a consumer by such defective product manufactured or sold by the deficiency in service relating to. These all are the definitions covered under Consumer Protection Act 2019. It was not covered under the earlier Consumer Protection Act 1986. Product liability actions, it means a complaint filed by the person before a district commission, or state commission, national commission, as the case may be, for claiming compensation for the harm caused to him. These all are the new definitions. Therefore, we are discussing these definitions. Product manufacturer, who is manufacturing a product, is a product manufacturer. Who is the product seller? The person who is selling the goods, a person who in the course of the business imports, sells, distributes, leases, installs, prepares, packages, labels, market, repairs, maintains, otherwise involved in the placing such product for commercial purpose, and includes manufacturer who is also a product seller and service provider. These all are the product seller. Who is not a product seller? A person seller of the immovable property, unless such person is engaged in the sale of the construction house or in constructions of the homes or flats. A provider of professional services in any transactions in which the sale or use of the product is only incidental thereto, but furnishing of the opinion, skills, or services being the essence of the such transactions. Then these probably we have covered all those the definitions. Once we have covered all those definitions, then you will try to understand, once there is a complaint, then how to file a complaint. What is the procedure to filing a complaint? Then we will discuss the basic draft, and before going to that, discuss about the basic draft, you should initially, once the consumer is approaching you, I will sharing the basic draft, how to draft a complaint and how you can approach to the court. The basic draft I am sharing with the format. What should be the format? How a complaint can be drafted? This is the format. We have experienced that you should not put the name of the party and person and all those. There should be the only format. So any of my professional colleagues who want to file a complaint before the state commission or district commissions, state commission, and national commissions, how to draft a complaint. Once the complainant approach you, then how it can be drafted, how to file a complaint before the district, state, or national commissions. So try to understanding things. First of all, once you are going to draft a complaint, first of all, you have to serve the legal notice. And legal notice, we have earlier discussed in our earlier sessions, how to draft a legal notice. Once the legal notice is issued, you are drafting, it should be very accurate. It is a first cut draft, and on the basis of this legal notice, your entire case depends. So in the other words, you can also say this is a beautiful love letter. So you should draft it very beautifully. So once the letter you will received by someone, of course, it should be impressive. And first impression should be, yes, whatever the content you want to put it, whatever the amount involved, what is the considerations involved, and what are the remedy you want, you all should cover. Address should be properly mentioned, date, it should be properly signed. This is the basic format of the legal notice. We have already discussed in the earlier sessions, because there is some running time is very short. So therefore, I am only discussing about how to draft a complaint before district, state, and national commissions. So once you are drafting, starting the drafting, this should be titled before the Honorable District Consumer Dispute Redressal Commission, so and so. Once you are in the before the state commission, then it is a state commission. and you are before the national commissions, because all are the original jurisdictions are lies with the district commission, state commission, and the national commission. I will also discuss about the jurisdiction. Therefore, the complaint number so and so of 2020-23. Once you are in 2023, then 2023. Once you are in 2024, then year should be 2024. Accordingly, you can put here. Then you can put in the matter of the matter between whom. Suppose you are the complainant, then you should put your name, father name, address, complete address with your mobile number and email ID. And in the same manner, to whom, against whom you want to file a complaint, then his name, father name, address, and email and mobile number. Once it is you are filing a complaint against the company, then the name of the company, name of his registered office, means address of his registered office, and his email ID and mobile number. I am emphasis on the email ID and mobile number only because of that we can serve the notice through email as well. And service some notice through email and WhatsApp is legally valid as the Honorable Supreme Court has pronounced the judgment. Yes, we can serve through email and WhatsApp. So all those things should be mentioned. First of all, you have to prepare an index. That is the very first page. You have to prepare an index. Index, there should be some mention that complaint under section so and so, affidavit in support of the complaint, then list of the documents, what are the documents you are relied upon, and if you are asking for the interim compensation, interim relief you are asking for, then you should also put that applications, and you should also place a wakalatnama on whose behalf you are filing the complaint. Then it should be signed by complainant through counsel. This is the index, first page. Then you will come on the memo of the party. Once the memo of the party, then again the full name, father name, address, and full name of the opposite party. Once there are the more than one opposite party, then it should be properly mentioned 1, 2, 3, and 4. All are the opposite party, and how this opposite party should be included, not included, who should be the party. You should be very aware about it, and before drafting a complaint, you should always keep in mind that who should be the party and who should be not a party. So once you are making a wrong party, then it is also very dangerous to you, and you will not succeed in your complaint. So before filing a complaint, you should be always well aware what is the jurisdictions of the court. It is jurisdiction with the district commissions, state commission. We will discuss on the jurisdictions on the later on, because I will cover all those PPTs through jurisdictions. But this memo of party is a very important, because once you are not make appropriate party, suppose you are filing a complaint before the district commissions at you may be Kashmiri case, then you have to look into whether the opposite party resides or carry on the business, or the complainant resides at that particular place, or cause of action arises. This is the territorial jurisdictions. Once you are making a party, you should be very sure that yes, where you are filing the complaint, it is within the territorial jurisdictions of that particular consumer commissions. Once you are making a party which is not within the territorial jurisdiction of that particular consumer commission, then your complaint is not maintainable. And once the opposite party will appear, file the reply, and preliminary submission will be taken that this consumer commission doesn't have a jurisdiction, it may be the fate of your complaint that after 1 or 2 years, it may be possible that after 4, 5 years, your consumer complaint will be dismissed. So how you will feel? It is a very pathetic situation. Once 4 or 5 years, your complaint will be dismissed on this ground that this consumer commission doesn't have a jurisdiction. And I have practical exposure of this fact that I always used to raise these objections. This consumer commission doesn't have a experience, and in my practical exposure, in my practical life, after 4, 5, just my dear friends, please. Please, my dear friends, don't disturb. Who is? I'm sorry, but please maintain the sincerity and dignity of this online sessions, please. I'm so sorry to say, but yes, once this is full name, address, the memo of the party. Thereafter, you will come on the title, how it has to be filed. That yes, once you are filing the complaint, that it should be clearly written that complaint under section 35 before the district commissions, section 47 before the state commission, section 58 before the national commissions. Then you have to mention in the very first line that complaint under section so and so of the Consumer Protection Act 2019. You're the basic complaint. Once you are making a wrong sections, then your entire complaint will be dismissed on this ground alone. Then once you are writing a complaint under section 47 before the district commission, then it is wrong, and your complaint will be dismissed on this issue alone. So you should be very cautious, very aware that your complaint should be filed under section 35, 47, or 58 as per the district, state, or national commissions. Then this is the introduction part, that you should, once you are filing a complaint, you should introduce yourself in the opening paragraph, that who is the complainant, who is the respondent, and what the complainant is doing business, what the respondent is doing business. Then what the transactions takes place, what are the transactions between the parties. These transactions have to be clearly mentioned. Yes, you have purchased certain goods and considerations involved. And thereafter, the defect and deficiency in service. What are the defects in your goods, or what is the deficiency in service? These should be the chronological manner the complaint should be mentioned. Then therefore the complaint may be maintainable. And thereafter, you will discuss about the rectifications and what are the, you want a remedy, and what can be remedy available to you. Suppose the goods are the defective goods, then what are the remedy available? It can be repaired. Then you can ask for, yes, it can be repaired, or the services is repairable. Then you can also ask for that, what can do by rectification of that particular goods or services. Other provisions of the law, rules or regulations, particular procedure is applicable. What are the procedures are applicable? What are the laws are applicable? Whether it is deficiency in service or whether defect in goods, and what are the provisions of the law, you should mention here. Then there should be an evidence. Evidence means you have purchased certain goods. Once you have paid the considerations, then you should mention what is the consideration you have paid. Once there is a receipt against that you should also edit that receipt. Is there any agreement has been executed between you and other party? Then you should also place on record the agreement, or anything related with that transactions you should place on record and mark as an annexure. Then you should also mention the jurisdictions, pecuniary jurisdictions and territorial jurisdictions. When the jurisdictions is only up to 50 lakhs, then you should go for the district commissions. If it is more than 50 lakhs up to 2 crore, then you should go for the state commissions. And more than 2 crores, then you can go for the national commissions. This is the original jurisdictions. And limitations. Limitations means under section 69 of the Limitation Act, 69 of the Consumer Protection Act, you have to file a complaint within 2 years from the date of the cause of action arises. Once it is beyond 2 years, then you have to move an application for condemnation of delay. So you should be aware that within 2 years you have to file a complaint. Relief claim. What are the relief you are asking for? That this relief is required, then you should ask for the relief, and in the last you should ask for the prayer clause, that most of the prayer, that is, I want this, and this should be provided. Suppose you are purchasing the goods, suppose you have purchased the mobile and mobile is defective, therefore the Honorable Commission may please to replace that mobile and new mobile may be provided. Or the compensation, if you don't want the mobile, then you ask for the compensations. You can ask for that amount of whatever the amount you have spent on that. You can ask for that. You can also ask for the compensation, interest, and all those things. Then you should be very clearly mentioned in your prayer clause, yes, that you want this. Unless until you will written here, you will not get anything. Then whatever you want, you should be very specifically mentioned in your prayer clause. Then that last is the verification clause, that you have verified that all those contents are correct and up to the mark. And this complaint has to be duly signed by the complainant and counsel And here also it should be duly signed by the complainant, and complaint should always be supported by an affidavit. Once you are not filing an affidavit, then your complaint is also not maintainable. Then you should always keep in mind, your complaint should always be supported by the affidavit. Affidavit in support of the complaint. And if the format of the affidavit is Mr. So-and-so, resident of so-and-so, do hereby solemnly affirm that I am the complainant in this matter, and consistent with the facts and circumstances of the present case and competent to swear this affidavit. The facts contained in the accompanying complaint, the contents of which have not been repeated for sake of the verity inclusive of the affidavit and proven correct. Again, the verifications. So this is all about the complaint, how to draft a complaint, what are the necessary ingredients should be there to drafting a complaint. So my dear friends, we have discussed about all those, what you can say, that we have discussed about the definitions of the definitions. We have discussed about how to draft a complaint, how to draft a legal notice. If any questions on this issue, then the friends can ask me. Then we will proceed further. If any questions, please. Any of our friends have any questions on this issue about the drafting of legal notice, about the drafting of the complaints, about the definitions, who can be consumer, who can be the service providers, and what is the product, what is product liability, and all those things. If anyone of us wants to ask any questions, please.
Sir, this is Niranjan Pandey, advocate. I have one question.
Yes, yes, please.
Yeah. Sir, can we make application under Section 40 of this Consumer Protection Act 2019 for restoration of any complaint if complaint has been dismissed by Honorable Commission due to non-prosecution, while this case was on a stage of final argument?
Irrespective of the stage, once there is an applications, once either it may be dismissed in default or ex parte, both are available. Once it is dismissed in default, then you can approach to that particular commission, because powers of the review has been given to the district commissions, state commissions, and national commissions. Once you are in the dismissed in default, you can immediately move an application. Yes, due to these reasons, I could not appear before the honorable commissions. So please revive my complaint, and that your complaint will be revived. It may be the subject to cost or maybe without cost. If the genuine reason, may be without cost. If there is not a genuine reason, it may be subject to cost. In most of the cases, the practical exposure, most of the cases are allowed subject to cost. Yes, but
As
it
per
will
my
be allowed
understanding,
and
it means,
restored to the original position. Yes, please.
sir, as per my understanding, it means district commissions are empowered to restore any complaint which has been dismissed due to non-prosecution,
Yes,
as per proper application submitted by the complainant.
yes, but as per the Consumer Protection Act 2019, means if the complaint has been filed after 20th July 2020, not as per the Consumer Protection Act 1986. Once you are dismissed in default as per the Consumer Protection Act 1986, then you have to approach to the State Commission through an appeal, and only the State Commission has a power, means upper authority has a power to restore that application or set aside ex parte order.
Okay, sir. Thank you, sir.
Please, most welcome. Yes, anyone, please.
Sir, I am having question. This side Vijay Tanwani.
Yes, sir.
Sir, sending of legal notice is mandatory as per Consumer Protection Act. Suppose I am filing direct case. Okay, so we
not
can file
mandatory.
direct case to.
Yes, we can file a direct case. It's not mandatory, but at least there should be precautionary measures should be taken. It may be possible that before filing a complaint, your grievances may be redressed. Once you are serving the legal notice, suppose I'm taking an example. Suppose once we purchase the mobile cost rupees 20,000, and once you serve the notice to that particular mobile producers, and your mobile has been replaced, why will go to the consumer court? Because once you will go to the consumer court, notice will be issued. Hardly it will take 2 to 3 months. And once you are serving the notice, your problem is redressed within 15 days. So precautionary measure, it is always advisable to serve the notice first. Once your work has been done within after serving a notice, your grievances have been redressed.
Okay,
So
sir.
this is
Well noted.
advisable, but
Thank you, sir.
not mandatory. Yes. Yes. If any questions, then otherwise you will proceed further. Okay, friends, still you have a time. After the session, you can also have a questions. Certainly, we will proceed further. How to, once everything has been prepared, draft is ready, you will approach to the court. And you will file a complaint before the consumer commissions. So first of all, you have to understand what is the hierarchy of the commissions. First of all is the district commissions, then the state commissions, then national commissions. Then you can approach the Supreme Court. These are the commissions, district commissions in one district commission in one district, state commission, one state commission in one state, national commission in the entire India, there is one national commission as of now. Then you can approach the Supreme Court. Against whom you can file a complaint? You can file a complaint against manufacturers, product seller, service providers, e-platforms. The new act added new concept and definitions of the product service provided by e-platforms. You can also, against whom you can file a complaint. Once there are service providers, you can also file against the service providers. You can also product seller, manufacturer, and e-platforms. You can file a complaint against e-platforms as well. Procedure for the Consumer Protection Act 2009. First of all, you have to serve legal notice. That's not mandatory, as I've already explained. As Mr. Vijay Tanwani has asked questions, that is very good questions. It's not mandatory, but it is always advisable to serve the legal notice. Then, once your grievances is not being redressed after serving the legal notice, then you can draft a complaint. You can approach to the complaint district commissions or state commission, national commissions as per your grievances. The first of all, that the very most important thing that you have to look into, what is the territorial jurisdiction, what is the pecuniary jurisdictions. Because territorial and pecuniary jurisdictions is a very, very important issue, and you have to look into what is whether this commission has the territorial jurisdictions or not. First of all, you have to look at territorial jurisdictions, means where opposite parties actually and voluntarily resides. If the opposite party resides in that particular jurisdictions. Suppose once you want to file a complaint before the district commission's Kashmiri Gate, then you have to look into what is the territorial jurisdiction of that Kashmiri Gate. Means opposite party has to be resides, or opposite party carry on the business, or has a branch office, or personally works on the game. Whatever should be the address has to be within that particular jurisdiction. Where the cause of action arises wholly or in part. Cause of action arises means within that particular jurisdiction, is there any agreement has been executed or any contract has been executed between the parties in that particular area, or where the complaint resides or personally works for him. The new provisions has been added in Consumer Protection Act 2019 to provide the consumer the better facility that where the consumer resides. Suppose once you purchase the goods in Delhi and you resides in the West Bengal, then you can file a case in West Bengal itself where you resides. This is the wonderful provisions added by the Consumer Protection Act 2019 for the facilitating the consumers. Wherever the consumer resides, he can file a complaint before that particular commission. This is the territorial jurisdictions. And once you are making a party and the memo of the party, you should always be very cautious while introducing the parties at the opposite party. Another thing is pecuniary jurisdictions. The pecuniary jurisdictions of the district commission, state commission, national commissions. The state commission pecuniary jurisdictions is whether the value of the goods or services paid as consideration doesn't exceed 50 lakhs. Whatever the value you have paid, that does not exceed rupees 50 lakhs. When the Consumer Protection Act 2019, with effect from 20 July 2020, the value was 1 crore of the district commission and up to 10 crore was the state commission, more than 10 crore was the national commission. But thereafter, 30th December 2021, there is a notification published in the official gazette, and with effect from 30th December 2021, the value of the goods or services paid as considerations has been reduced from 2 crore to 50 lakh. So as of now, the district commission's jurisdictions is up to 50 lakh, State Commission's jurisdictions up to 2 crores and National Commission is jurisdictions up to more than 2 crores. So this is the applicable after 30th December 2021. So you should be always be very aware what is the jurisdictions of the State Commission, what is jurisdiction of District Commission, what is jurisdictions of the National Commission. So once you are discussed about the jurisdictions and once your complaint has been filed, the notice will be issued to the opposite party. Once the opposite party receives the notice, appears before the court, from the date, this is a very important provisions that the opposite party once appear, then the opposite party have to file the written statement within 30 days. That may be extended up to 15 days more. Once the 45 days is over from the date of the receiving of the complaint, you are no more in the picture and there is no remedy available to you. The opposite party, whoever is the opposite party, he should be very cautious, very important provisions of the law that you have to file the reply within 30 days and maximum up to 45 days. Once it is not filed within 30 days, then you are no more in the picture. And that can be extended up to 15 days more. Means once it is 30 days is over, then you have to move an application for condonation of delay that yes, it has been filed more than the 30 days after receiving the complaint. But anyhow, it cannot be extended beyond 45 days. Supreme Court is very clear in the JJ Merchant case. I will discuss that case also. So once you are the opposite party, you should be very cautious. All the professionals should be very cautious. There is no remedy available once the 45 days is over. Always keep in mind, once you will receive the notice, immediately you should drop the reply within 30 days, try to within 40 days, but it can be extended only 45 days, not more than that. Once no reply has been filed and opposite party did not appear, then the Consumer Protection Commissions may proceed ex parte. And as per the Consumer Protection Act 2019, every district commissions, state commissions, and national commissions have their mediation cell. Most of the commissions normally practically issue the case, refer the case before the mediations, try to mediate and go and try to settle it. Once it is settled, then everything is over. Once not settled, then the Consumer Commission will proceed further. So specifically, mediation cell has been, mediators has been in with the every district commissions, state commissions, and national commissions, mediation cell. Commission shall within 5 days refer the matter for the mediation, section 337, subsection 2. And once the opposite party appears, file their reply, then the complainant should file their rejoinder. And once the complainant did not appear before the court, then the proceeding matter may be dismissed in default. So once both has to be appeared, complainant has to be appeared, opposite party has to be appeared. Anyone of is not appear, then it may be ex parte, it may be dismissed in default. Once it is ex parte, then the review by the district commissions. You can move an application for set aside ex parte order. Ex parte order may be set aside subject to cost, or it may be dismissed in default, then set aside the dismissed in default order subject to cost. And once there is everyone is appearing, then the evidence by the first of all, the evidence has to be filed by the complainant. Then the evidence has to be filed by the opposite party. And if applications filed by the cross-examination by the complainant, opposite party is subject to allowing application by the commissions. If you want to cross-examine the complainant, you can cross-examine the complainant. If you want to cross-examine the opposite party, you can also cross-examine. But in the prevailing circumstances in the Delhi state commissions, there is no cross-examination that is going on. Only the evidence filed on the basis of the evidence. All those matters will be decided. But in our experience, in the most of the South district commissions and state commissions, mostly the cross-examination has been happened. Written arguments by the complainant and then written arguments by the opposite party. Once the evidence is over, then the written arguments will be filed by the complainant and also the written arguments will be filed by the opposite party. Both the written arguments are filed, then the matter is fixed for the final arguments. And once the final argument is over, then the matter is reserved for order and further pronouncement for the judgment. Once the order is reserved, then it is listed for the pronouncement of the judgment. Pronouncement of the order. Once the order is pronounced, you may be satisfied, may not be satisfied. If any error apparent on the face of the record of any order, then review can check this. You can move an application that there is an error apparent. Suppose error apparent in the sense, like suppose if you paid 20 lakhs and by inadvertently it has been written as 21 lakhs. So you can move an application that it is not 21 lakhs, it is 20 lakhs. So it can be corrected. Means whatever the basic corrections in the order, you can move an application for the review that yes, it has to be corrected and it has to be within 30 days from the date of the order, then it can be corrected. Commission will review its order. This powers has been vested by the consumer commissions after Consumer Protection Act 2019. The review power was not vested with the district commissions or state commissions in Consumer Protection Act 1986. Only the review powers are vested with the National Commission. So now the Consumer Protection Act 2019, I am also telling it what is the difference between 1986 and what is the difference between 2019. What newly added in the 2019. If not satisfied your order of the district commissions, then you can file an appeal before the state commission. An appeal has to be filed within 45 days from the date of the receiving of the order. Date of receiving of the order means the consumer commissions normally used to serve the notice free of cost to the opposite party and complainant both. Then the day will be counting from the date we received the order from the district commissions. 45 days from that particular day. Once you didn't receive the order, then you can approach to the district commission, take a certified copy, then the 30 days will be 45 days will be counted from the date of the receiving of the certified copy. These all are the provisions are the very important. Once you will go for the practical things to be done, then this is very important. Otherwise, once you are not filed the appeal within 45 days, then you have to move an application for condonation of delay. And it may be allowed, may not be allowed. So on the condonation of delay, courts are very strict. That is, once you are in the consumer commissions, you have to be within the time. Once they met it before the state commissions, then the notice will be issued. It may be rejected at the very prima facie case. Yes, request is not maintainable, dismissed. Otherwise, the notice will be issued. Once the notice will be issued to the respondent, the opposite party, the respondent will appear, and it may be filed there any objections if you want to file or reply want to file. But in the most of the cases in the appeal matters, mostly courts only consider the appeal and say to the opposite party that yes, come appear respondents and file their written arguments if you want to say something and address the argument. Final argument, and after final argument, again the matter is reserved for order. And after the pronouncement of the judgment, you are not satisfied the order of the state commission, then you can approach to the national commission, that is within 30 days. Not satisfied with the judgment, second appeal to the national commissions. Then again, the same procedure that the notice will be issued. Either it may be rejected at the admission hearing, it may be rejected at admission hearing, or notice will be issued. Once the notice will be issued to the respondent, then the respondent will come again. They file written arguments, and then for the final arguments addressed by both the parties and matter is reserved. Then the pronouncement of the judgment. Not satisfied with the pronouncement of judgment of the national commission, then you can go to the Supreme Court. This is the hierarchy. How you can proceed further. We have already discussed the tutorial and this is one of the most important thing, that is unfair contract that has been introduced as per the Consumer Protection Act 2019. It was not introduced in Consumer Protection Act 1986. Unfair contract, jurisdictions of the unfair contract is only lies with the state commissions and the national commissions. Complaints unfair contracts where the value of the goods or services paid doesn't exceed rupees 2 crores, and here in the national commission doesn't exceed 2 crores. Concern exceeds 2 crores rupees, and once they exceed 2 crores, then to the national commission. Unfair contract means contract which is unfair. Then you can challenge that contract, and the state commission and national commission has a power to set aside that particular contract or that portion of the contract. The entire contract can be set aside. This is the violative of the law, or this is unethical or unfair practice. So these powers are vested under Consumer Protection Act 2019 to the state commission, national commissions only, not with the district commissions. This is a very important judgment. C. Venkatachalam versus Ajit Kumar S. Shah and others. Honorable Supreme Court has decided on 29th August 2011 that it is not mandatory that only the advocates can be appear before the honorable district commissions, state commission, and national commission. It is not mandatory. Any the authorized persons who can appear before the district commissions, state commission, and national commission. In all the tribunals, Consumer Protection Act is also a tribunals. In all the tribunals, any authorized representative of the complainant or complainant himself or opposite party himself appear, they can address the argument, do everything. Not mandatory that only an advocate can be represented. In the most of the district courts, high courts, and supreme courts, only the advocates are allowed to represent on behalf of the client. Other professionals are mostly not allowed, Honorable Supreme Court says very clearly, other professionals are not allowed to appear before the court. But yes, in the tribunals, all the professionals are the person who is the competent knowledge of that particular subject matter or that particular case. They can appear and contest his case without appearing the specific professions. This is a very important judgment that Dr. J.J. Merchant and others versus Srinath Chaturvedi. This is decided in 2000. This judgment that Honorable Supreme Court says, and after there are plenty of the judgments have been passed, and all those judgments, D.T. Merchant and others versus Srinath Chaturvedi has been mentioned that the district commissions only have a power to entertain the written statement that has to be filed within 30 days, or that maximum up to 15 days, maximum 45 days. Once it is beyond 45 days, then you don't have any options, and all those you are out of the race. So you should be always very cautious about it. Then the review powers we have already discussed. Then the revision, there are the certain revision powers that are vested with the state commissions and the national commissions, that the state commissions, it feels that the district commissions has exercised jurisdictions not vested with him by law or has failed to exercise a jurisdiction, so vested or has acted in exercise of a jurisdiction illegally or with material illegality, it can call for the reports and pass appropriate orders. Same powers are vested with the national commission side base. You can file an appeal for state commission, national commissions, then go to the Supreme Court. This is one of the most important things, that Central Consumer Protection Authority that has been introduced in the Consumer Protection Act 2019. There is main role to protect the rights of the consumer by cracking down unfair trade practice. And once you feel that any unfair practice is being done, then you can approach the Central Consumer Protection Authority, and there is an investigating agency, there is an investigating matter, and unfair trade practice has to be cracked down. Also, false and misleading advertisements which are prejudicial to the interest of the public and consumers. It says office situated in National Capital Territory. So this is the Consumer Protection Authority. Requires establishing central government its main product, and how it functions. Its function is to investigate and inquire into the matter related to violation of the consumer rights. It will have the power to initiate actions either suo motu or the complaint received, review the matter relating to and facts enjoyment of the consumer rights, will also recommend adoptions of the international covenants and best international practices on the consumer rights to ensure effective enforcement of the consumer rights. If any unfair trade practice is being adopted by anyone, then the Central Consumer Protection Act Authority has a power to curb that unfair trade practice or to stop unfair trade practice that can pass an order. It recommend under Section 20, a person aggrieved by the order passed by the Central Authority under Section 21 may file an appeal to the, once there is any, you are aggrieved by the order of this Central Consumer Protection Authority, then you can directly approach to the national commissions to an appeal. This is the mediation sections. We have already discussed. All those district, state, and national commissions have their mediation center. The matter can be referred to the mediation center, and the mediation center will look into the matter. Once they are settled, everything is over. Once they are not settled, the matter again back to the district commission, state commission, national commission, and matter may be dealt with according to that. One, because we have already discussed with what is the in 1986 and what is the 219, what are the provisions are applicable, not applicable, what new in this section. And this is one of the most important decisions. In the most of the agreements, we have the what we can say, we have the arbitration agreement. Once there is an arbitration agreement between the parties, then the Consumer Protection Act doesn't bar to doesn't bar that, yes, you cannot approach the commissions. Once there is an arbitration act, it is not mandatory to go for the arbitration. Once you are approaching to the civil court, and once there is an arbitration agreement in the agreement, arbitration clause in the agreement, then you cannot approach the civil court, and you have to mandatorily go for the arbitration. And civil court doesn't have a power to entertain such an suit or petition, and it has to be dismissed and matter will be referred to the arbitration. But in the Consumer Protection Act, even though there is an arbitration clause in the agreement, but no one can stop the consumer to approach to the Consumer Commission, State Commission, or National Commissions. Arbitration clause doesn't bar the consumer to approach to the commissions. So this is the higher bench judgment of the Honorable National Commission 3-bench judgment of TAPS versus Simar MDF India Limited, that is very clearly stated that yes, even the arbitration clause in the agreement doesn't bar the consumer to approach the commissions. So my friends, I had tried to cover all those things, how you can approach to the commissions, how grievances can be redressed, and what are the definitions, who can approach to the commissions. I am trying my level best to summarize the things within 1 hour for the definite period of time. Thanks, friends. Thanks to all of you for the patience hearing. And now we have the question and answer sessions. All of my friends open and switch on their videos and come and directly interact with me. If there are any questions, please ask. If there are any doubts, please ask. Please switch on all our videos so that you can see some beautiful faces. Yes,
Sir,
please.
this is Niranjan Pandey again. I have another question.
Yes, please.
That is related with fixed deposit of any company. Suppose if I am buying a fixed deposit of any particular company, and
Please.
at the time of maturity, they are
Yes.
denying or they are, not entertaining my request to give the maturity amount. Then,
Yes.
as per Consumer Protection Act 2019, I
Yes.
am a consumer or not?
Yes, you are consumer. 100% you are consumer.
Sir,
There is
I think
deficiency in services.
some judgment passed by Supreme Court, any investor can't be a consumer, if I am not wrong. So I am requesting
that
kindly be
is
elaborated.
not
in
a
this
commercial
matter.
purpose. That is not your investment is not for the commercial purpose.
Yeah.
Suppose there is an Honorable National Commission, there are plenty of the judgments, then you are investing in the 3-4 properties in your vicinity or anywhere.
Right, sir.
That is only for the livelihood. Yes, of course, whatever I am investing, that is my fixed deposit, and you are providing the services that yes, at a certain period of the time, you will refund it. And once you are not refunding, there is a clear deficiency in service. You can approach.
Okay, so it means I am a consumer and I can approach.
Yes, 100% you are consumer. 100% you are consumer. And I have personally filed such type of the cases in the cases of the Sahara, because in the most of the cases, Sahara is making the default.
Right, sir.
And we have approached to the commission, and commission has issued the notice and direct him that yes, you have to refund the amount.
Thank you, sir. Understood.
I'm dealing with such type of the case.
Thank you, sir.
Please, most welcome. Yes.
Good afternoon, sir.
Yeah, good afternoon, please.
Sir, my question is, can we appeal against NCDRC order or is it final?
No, you can also appeal to the NCDRC order before the Honorable Supreme Court. We have already discussed that district commission order can be challenged before the state commission order can be challenged before national commission order can be challenged before the Supreme Court. Supreme Court is the highest authority. Whatever the order passed by the Supreme Court, that is the finality.
Sir, what about Supreme Court's order? Can it be challenged?
No, Supreme Court is the final authority.
Okay. Thank you, sir.
Because there is no authority apart from the Supreme Court, you cannot challenge it. Of course, there should be some end somewhere.
Okay, thank you, sir.
Yes, Mr. Gyan Prakash Saxena ji, if you want to ask some things. Please unmute your mic. Mr. Gyan, please unmute yourself. I am not audible. Yes, please.
Hope you are getting now, sir.
Yes.
Thanks for sharing all the beautiful information with all of us, sir.
Thank you.
And I would like to clear, I am not advocate by profession. I am as a AR work in consumer court and also won the cases in district forum and national commission, sir.
Please.
Yeah. When
Very
you
good.
shared the AR a person can handle by own or through AR. It was great information to all the persons.
Yes, yes, there is specific judgment of the Honorable
Yes.
Supreme Court.
Yes,
Yes,
sir.
anyone can represent on behalf of the anyone.
Sir, I have one question.
Yes, yes,
If a person go for appeal in Supreme Court
yes.
and due to non-prosecution, if matter is dismissed, is there any remedy?
Yes, yes, you can move an application for the revival.
Revival.
Yes, yes, it can be
Thank
revived.
you, sir. Thank
Yes.
you.
Can be revived.
Thank you, sir. Thank you.
Please, most welcome.
Sir, one request. Please
Yes.
share whatever you share the information through PPT.
Yes,
It
yes.
is my humble request to share that PPT with all.
Yes, yes, it is always available through YouTube channel. Whatever I have,
Okay, that's
I
great,
have,
sir.
whatever I have discussed here, take a session. Entire session is available on the YouTube Vidya Vijay Foundation.
Great, sir.
You can this whatever the session, because I used to take a session on 2nd and 4th Saturday on the different topics.
Okay.
And you can also connect with my Vidya Vijay Foundation, that is WhatsApp
Sure, sir.
group.
I will, sir.
And
And-
certainly whatever I may try by level best
Yeah.
for this platform to share the knowledge, whatever I have.
Yeah, you
course.
shared. Great job, sir. Once again, I tell this.
Thank you.
And thank you for inviting me, sir. Thank you. Thanks a lot.
You can also drop your number in the chat box. Certainly will add you.
Sure, sure, sir. Sure.
Keep updating me. Yes, please.
Sure.
Yes, any other friends?
Good afternoon, sir.
Yeah, good afternoon.
Sir, my question is, when we already have civil courts, then why consumer courts were established?
Consumer courts are specifically established to redress the grievances of the consumer. What happens in the civil court, once you file a recovery for the civil court, it takes approximately 4 or 5 years. And the procedure is a very lengthy procedure. And to cut short the procedure before the Consumer Protection Act, consumer, especially for the consumers, because the person who is the consumer can only approach to the Consumer Protection Act. A person who is not a consumer, they cannot approach to the Consumer Protection Act. So this is the very shortcut method. Within the particular time, within the 60 days, 90 days, the your grievances is being redressed. So this is a specific designed act for the consumer, that his grievances can be redressed within a very short period of the time. Hardly it takes 1 to 2 years and your grievances is being redressed. Once we will go to the civil court, it will at least take 4 to 5 years, because written statement, rejoinder, then the framing of the issue, then evidence, cross examinations. There are the lengthy procedures. Because of the procedures, yes, this act is specifically designed by the Parliament for the benefit of the consumers.
Okay, thank you, sir.
Most welcome.
Sir, I have a question.
Yeah, please.
Sir, is there any provision for transfer of cases from one district consumer commission to another district
yes,
consumer
state
commission in
commission.
another state?
Yes, the state commission has always had the power to transfer the cases from one district to the another district. National Commission has a power to transfer the cases from one state to the another state. This is a.
So, sir, is there?
Yes.
Please. Is there any particular reason that we have to mention to the commission?
Once you are not
Because of
satisfied with
this-
the once you are not satisfied with the particular, suppose like as I'm giving an example. Suppose you have filed the case at Kashmiri Gate, and probably after later on you came to know that yes, Kashmiri Gate doesn't have a jurisdiction to entertain such a complaint. Then immediately, rather than to dismiss that complaint and again file a fresh, you can approach to the state commissions. Yes, my lord, this is the situations, and this consumer protection doesn't have a live jurisdiction. Therefore, I want to transfer this case from this commission to this commission to this commission. Immediately, the state will do. The state commission will do. This may be the reason, or any other reason. Suppose you are not satisfied with any honorable judges or president or something. There are the certain relatives of that presidents are appearing. So you can take an action there. Yes, he is the relative of so and so. Then he is not the independent person. So it may be case transfer from this court to this court. You can take it.
Sir, my concern is if one of the parties are willing to get the matter transferred because of their difficulty to come to that commission on a regular basis, could it be the ground for the transfer?
Probably not. Probably the court will not consider it, because to come to the court to the difficulty, it is not a ground to transfer the matter. Probably not. But yes, you can argue the matter. Yes, this is the genuine reason, because you are not able to move, or you are in such a position that you are the bedridden. Hardly it takes 4 hours, 5 hours to come there, and nearest consumer court you can approach within 5 minutes. So this may be the considered by this honorable state commissions. May. You see, there is no hard and fast rule what will be considered by the state and what will not consider, because this is the discretionary power. Once you are convincing to the honorable court, yes, this is my genuine reason, and by your convincing arguments when the state commission is yes, agree, certainly it will be transferred. Because there is no hard and fast rule that this should be the ground only for the transfer. But there should be some, act says, yes, there should be some genuine ground for transfer. And once it is satisfied by your genuine ground, certainly it will be transferred.
Thanks for the clarification.
Thank you. Most welcome.
Sir, good afternoon. I have one question. If any arbitration, any arbitration clause mentioned in the agreement executed between the builder and buyer, then the buyer can go before the consumer court.
Yes, we have discussed the case law of the AFTAB, the Honorable National Commissions. If the arbitration agreement in the arbitration clause in the agreement doesn't bar the consumer to approach to the Honorable Commissions, district, state, and national commissions. AFTAB case is very clear. Honorable 3-1 judgment of the National Commission said yes, even though there is an arbitration agreement, but cannot be restricted to the consumer to approach to the district commission, state commission, national commissions.
Thank you, sir.
Most welcome. Yes, please. Dr. Sanjay Mittal. Am I audible? Dr. Sanjay Mittal, Dr. Gopala, Dr. Ajay Singh. Sir, is there any questions? Kisnada? Yes, good afternoon. How are you?
Good, fine. So session was too good.
Thank you. If you want to ask any clarifications on any issue.
That's why I was listening very patiently.
Yeah, thank you. Thank you for all of the appreciations. All my friends for the present sharing.
Fine, thank you, sir. Thank you.
Thank you. If there is no any question, though, probably you can end the session.
Yeah.
And certainly we'll meet on the 4th Saturday with the different topics. And certainly I will try my level best to whatever the sharing the knowledge is one of the platforms. And any of our friends want to share their knowledge through this platform, they are also most welcome. Whatever the topics they want to discuss with us, they can discuss with us, and certainly this platform.
Thanks for sharing treasure brilliantly.
Thanks a lot, sir.
Thank you.
Sir. Thank you.
Thank you. Namaskar.